and welcome back to Military Law Talks. So, I've done a few videos on probationary federal employees, what they are, and kind of explaining some litigation that is surrounding probationary employees. And recently, President Trump issued an executive order discussing probationary employees and changing regulations regarding probationary employees. So, that's what today's video is about. If you like this content, please click the like and subscribe. Again, I'm a new channel, so it would help me out if you subscribe to the channel. It helps with the algorithms. So let's get into it. Okay, so this is the executive order. So it's called Strengthening Probationary Periods in the Federal Service. It was signed on April 24th, 2025. And so the purpose, it lays out the purpose that the American people deserve. I'm reading from the executive order. The American people deserve a federal workforce that is high quality, efficient, dedicated to the public interest, and no larger than necessary. Probationary periods for employees in the competitive service and trial periods for employees in the accepted service have provided a long-standing critical tool to assess the newly hired federal employees before finalizing their appointments to federal service. However, so next paragraph, the Government Accountability Office has documented, however, that agencies are not using the probationary and trial periods as effectively as they could to remove appointees whose continued employment is not in the public interest. And that's true. I've seen that in my years of government service, that oftentimes employees that were problematic in their probationary periods weren't removed. And then the longer they're in government service, really kind of the harder they are to remove from government service. Because as I explained in earlier videos, probationary employees have less due process rights than statutory employees. And so there's more required for the agency to remove statutory employees versus probationary employees. And so the executive order goes on. It says, as a result of this failure to remove poor performers, agencies have often retained and given tenure, that means allowing them to be statutory employees, to underperforming employees who should have been screened out during their probationary employee period. Now, OPM has given this guidance. Remember, OPM is the government's HR. And so they have given guidance to supervisors of probationary employees to tell them, use a probationary period as an extension of the interview, like the hiring process. And you should do periodic reviews within the first 90 days, 180 days to assess, is this employee a good fit? Are they performing to standard? And if not, remove them, then do not wait to remove that employee. And so the EO goes on and explains, conditions of good administration require that an agency approval should be required before probationary employees become tenured federal employees. As the Merit System Protection Board, and so remember, the Merit System Protection Board is a government agency that is kind of the first appeal right. So if an employee has an adverse action, like a removal or termination, then they can appeal to the MSPB, the Merit System Protection Board. And that is this administrative remedy that they have to seek first before they can go to federal court. So as the Merit System Protection Board recommended in 2005, in its 2005 report, the probationary period, a critical assessment opportunity, there should be, quote, procedures so that a probationer does not automatically become an employee in the absence of agency action, end quote. And in the absence of agency certification that probationer will be an asset to the government, quote, the probationer's employment should automatically terminate upon expiration of the probationary period, end quote. This order directs this common sense change. And this is in line with Trump administration, right? Kind of their almost slogan is common sense. Like, let's just go back to common sense. And to be honest, this is a total common sense recommendation, and I'm actually surprised that it's never been put into place prior to this. Particularly, it wasn't put into place during the first Trump administration. And so it's kind of interesting that it's from this 2005 report and has never been put in place. And so that's what this executive order does. It puts in place essentially that probationary employees don't automatically become statutory employees when their probationary period is over, that the agency actually has to take some sort of affirmative action. They have to determine that, yes, the continued employment would benefit federal in service. And so they have to make an affirmative determination. Otherwise, that probationary employee, under this new executive order and the new regulations that this executive order puts in place, is terminated. And so that's incredibly big paradigm shift, because again, previously probationary employees, just as soon as the time passed, they get a new SF-50, standard form 50, that says they're now a statutory employee. And really there's no kind of, it just happens. It happens with the passage of time. And now this changes it. And so it says that the agency has to do something, or if the agency fails to act, maybe they just even forget, then the employee is actually terminated. And it lays out that if that happens, that the agency kind of like accidentally, kind of negligently doesn't realize that the probationary period or the trial period is ending, and then that employee is terminated just due to agency inaction, then agency heads or designees can, within 30 days, ask for reinstatement of that employee. And so that mechanism is in place with this executive order. However, this executive order, like I said, it requires actual action by the agency. And so it puts in place new executive orders or new regulations. It repeals previous regulations. And then it has the actual regulation here. So this is the new regulation. So you can read it. It's on whitehouse.gov. You can read it for more information, but it essentially just explains what I explained, that there's this trial period that is required, and the agency, someone, either the head of the agency or some designee, I'm assuming probably it'll be some agency head at like an installation office level, pretty high level, I would assume, but someone who can actually make that determination. Is this employee beneficial? Should they stay? And actually the regulations stipulate that they need to have like a meeting with that employee to either tell them, yes, you're going to stay, or no, you're not. And let's see if there's anything else that I wanted to cover. Yeah, and then it says that the employee on probation or trial period bears the burden of demonstrating why their continuation in employment through the finalization of their appointment to federal services in the public interest. And so that's a shift too. Like now it's on the employee to essentially show their worth, show their value to the agency. Let's see. And then, yeah, this is what the agency has to take into consideration when determining whether that probationary employee should continue. The employee's performance and conduct, needs and interests of the agency, whether the employee's continued employment would advance organizational goals of the agency or the government, and whether the employee's continued employment would advance efficiency of the service. And then it says, before an agency terminates the service of an employee serving a probationary or trial period, it shall notify such employee in writing as the effective date of the agency. And if the agency fails to make a certification under this Civil Service Rule 11.5, due to an administrative error, the agency head may petition the director of OPM within 30 days of the date of termination to reinstate the employee. And then it doesn't apply to probationary employees that are just probationary due to promotion, transfer, otherwise reassigned, unless there's some sort of like concurrent probationary period. So it's essentially just like new hires to the government. And then there is a mechanism for appeal that that it directs the director of OPM to implement regulations to allow some sort of appellate rights by that probationary employee. And then it says, except as otherwise required by law, such appeals will be the sole and exclusive means of appealing terminations during the probationary or trial period. Meaning that, unless it's due to discrimination or some other mechanism allowed by the law, that the employee won't have any other additional legal rights to appeal. They can only appeal as directed by OPM. All right. And then, then it just gives dates of like effective dates. Essentially, this EO goes into effect immediately. However, it does direct agencies to come up with like a list of all the employees that will be impacted. And then that doesn't go into effect until 90 days after this EO was signed. And so that is the EO, the new EO on probationary employees. And so, again, lots of changes are happening to federal government employment. So I will be following those changes in this space. So if you like this content or got value out of it, please like the video, share the video out there with others that you think would like this video. And then please subscribe to my channel. I'm a new channel, so help me grow. And thanks for tuning in. I'll see you in the next video.